Okay, as we usually do, our afternoon segment's more financial planning focused, and it is my pleasure to welcome back Kevin. This is your third time or so, or second or third?
This is my third time.
Third time. And Kevin does estate and elder law with the Galligan law firm. And Mary retired, right? Or emeritus?
She more like an emeritus. So Mary Galligan, who's the founder of our firm, has worked there for probably 30 years at this point. She's stepping back to mostly work on client education more than direct client services, but is still very much there.
And Tonya Knauth, you have your own practice.
I do.
And we are very, very happy to have both of you here today. I had this, it may have turned out to be a crazy idea, but I said, I'd like to talk about power of attorney. And I'd like to kind of get detailed on it because people sign their documents and they sign this thing called power of attorney, and it's kind of like, okay, power of attorney. And I thought it would be really good for us to do some detailed talk about it because it comes up very, very regularly in our office. Very often with, financial power of attorney. There are forms that Fidelity has to establish a power of attorney, and I'll have some questions about that. And then people have their own power of attorney written by their lawyers, like Tonya and Kevin. And then there are medical power of attorneys. And increasingly, this is a topic that's important to, as we all age, for ourselves and our families. So welcome to both of you. And the first question is, why do I need a power of attorney? Tonya.
Thank you, Leonard. I want to first go back and say I'm really glad to be here. This type of gathering and this type of education is an important piece of my practice. I always enjoy doing it. I appreciate the relationship that I have with financial advisors and especially New Capital Management. And this is a great attendance, so that means you all are engaged in your financial planning. And so kudos to all of you. Why do you need a power of attorney? Because it is, in my opinion, the most effective tool for someone to assist you through both your periods of capacity, but more importantly, a period of incapacity. If you become incapacitated, maybe through no fault of your own, we come up with all sorts of macabre examples in my office, but step off a curb and get hit by a bus is one that we say a lot. If you're incapacitated and someone needs to direct your finances to take care of you, if there is no power of attorney, the only solution is a very expensive guardianship. So in order to avoid that, a simple power of attorney, carefully crafted while you have capacity and while you have the ability to choose who would support you and what powers you would grant them, is the most effective tool. Kevin, you have anything?
I do. I have a little bit to add to that, and thank you for having me. I would say that I heard it put one time that the power of attorney is the most important estate planning document. People think of the will, they think of the trust, and these are obviously, we're certainly going to agree they're very important, but the power of attorney is very critically important because it really is about you in a way the will or the trust isn't. Those kinds of things are designed usually to take care of people after you're gone, other people, and of course that's very important to you, but the power of attorney is about making sure there's someone available, should you be alive, who can pay your bills for you, or you are really the one who's hurt by the lack of this. If a medical bill needs to be paid, that's what the agent under a power of attorney is going to do. So those documents, this document is the one that's so important because it really is more about you. And as Tonya was alluding to, in some ways it's so important to have because the not having it can be such an expensive proposition, okay? So as she was alluding to, if you don't have a power of attorney, unless there's some workaround for being able to make decisions for you, that often does mean you have to go through guardianship, which is a core process. It can be very difficult on the family. It can be certainly very expensive. It's the difference between a power of attorney, you choose who you want to act for you, you choose the parameters like we'll talk about today, compared to a guardianship where someone comes forward and the court takes the power from you and gives it to said person. All right, so it's much more difficult, certainly much harder on the family process, which makes the power of attorney valuable in both respects.
Is there any reason why you would want to have power of attorney if you're not incapacitated? Do people do that? And is there any argument for that?
I'm going to jump all over that one. Absolutely yes. Absolutely yes. So there's a 1,000 reasons why you do. The first and easiest one is just a matter of convenience. Like you see this a lot between spouses. People will assume that as a spouse they can act for the other spouse. That is not necessarily true. It can be in certain contexts. But if you think about it, there's no automatic person who's allowed to act for you. So having a person delegated during lifetime can be very, very helpful. That could be, I don't want to go to the bank. I can't go to the closing, or you just want to delegate to that person so they can act if you can't. And then separately, I'm actually a big fan of this one. It's not the easiest conversation, but sometimes we talk about this as though incapacity is a very binary thing. You're either incapacitated or you're not. And that's kind of how we have to conceive of it, because we need a yes or no at some point just for ease of administration. But the truth is, incapacity is not a light switch. It's capacity's here, and then some days it's here, and then some days it's here. That could vary throughout the day. And so having a power of attorney appointed is sometimes just prudent, not because you're incapacitated, but because you can have someone who can help you. You know, you can have someone who's involved, who can help you not make a mistake, excuse me, as incapacity maybe starts to take hold. So just having the convenience of it is extremely helpful.
What he said. I, every day, recommend to my clients that they make their durable power of attorney, their financial power of attorney, immediately effective. Now, note that we're speaking exclusively about financial power of attorney when we're talking about while you have capacity. Assume we're talking about your finances. Yes, there is a gray area oftentimes that we go through. Sometimes we get better or worse in our lives. In order to use a durable power of attorney that is only effective upon your incapacity, it requires a doctor's letter that says you are incapable of managing your affairs. I don't know if there's any physicians in the room, but doctors don't really like to write those letters. It's a very difficult thing to get. So simply for logistics, if my client trusts the person that they are naming as their agent, I don't see any reason why they shouldn't go ahead and name them with immediately effective powers. Again, between spouses, I mean, maybe your spouse travels internationally and there's going to be a real estate closing. It enables you to sign their name. So it's for convenience and to overcome what might be future logistics difficulties during some gray period of incapacity.
Our daughter, Abby, just turned 18, and we put in place some documents for her, and included in that was a power of attorney.
Right.
I'm guessing that many, if not most, 18-year-olds don't have, and 20-year-olds and so on, don't have that document in place. It's something that we at New Capital are trying to get better at, reminding our clients that you've got young people in your lives. They probably need those documents. Could you talk a bit about that and the role of power of attorney in those documents for a young person?
Absolutely. I also have one who recently turned 18 and one who's 20, and they both have powers of attorney because of who their mom is. And all their friends have powers of attorney, again, because of who I am. The day someone turns 18, in the eyes of the law, they're a legal adult. Whether it should be that or not is a whole different debate. But the day they turn 18, parents no longer have any legal right to transact business for them on a regular basis. So what we do as a matter of course for 18-year-olds is give parents the ability that they have had previously, and most people want to continue to have. We appoint their parents as agents under their powers of attorney. I would say that I in those cases, the 18-year-old is my client. The parents are not my client. The 18-year-old has a confidential conversation with me where we talk about the pros and cons of what they're doing, and they make their own decisions. Because again, in the eyes of the law, they're a legal adult. But yes, I do recommend it, especially before they leave home. The nightmare scenario is that your child or grandchild is somewhere else and needs something, and you have no ability to help them over the phone or by email because you don't have a legal document giving you any right to transact business or make decisions for them.
I have a few things to add. So it's really interesting to me that this has been a recognized market need in recent years, where I have seen clients request the college estate plan, which we have done for people. It always comes, you usually get the call in June because they just graduated from high school. They're going somewhere in the fall. And then we basically end up doing it's a fairly limited plan, as Tonya was describing, but a limited plan that covers things like powers of attorney. I think it's also very helpful because, as she said, that child, when they hit 18, becomes a legal adult. They make their own decisions. But much like the incapacity is, a binary question, the age of majority is a binary question. You're 18 or you're not. But your capability of acting when you're 18 in a day is really no different than when you're 18 minus a day. So sometimes having a parent as an agent under a power of attorney means they can still make the calls to the bank, or they can still make sure that financially they're doing what they're supposed to be doing. Or this bleeds into a different conversation, I suppose, too, but to some degree, God forbid there's some kind of an emergency, then you might have medical powers of attorney put into place because that person is an adult, and then you have the appropriate, most likely the parent who has been named, and then can take action as well. So it's actually something I think people are more and more aware of. And just one more tackle onto that, we live in a more mobile society. That includes with things like kids going off to college. So it's not just that they stay here, they go to college abroad, they go to college throughout the country, they travel more. And so their lack of availability, where they might have to have someone act for them, is more common than it used to be. So it's actually a fairly important market need as far as that goes.
Why shouldn't you just wait until advanced age to go ahead and put in place a power of attorney, or wait till you need it?
I feel like I'm going to jump all over that one too. So one common human problem is we all think we have more time than we do, and incapacity is unfortunately a really good example of that. So one thing that people think of, and you see this in the estate planning context, is they always assume they have until they die to update something, or they have until they die to do whatever it is that they were going to do. The truth is, incapacity happens first, and as I said, it's not a yes or no, it is a spectrum. So it becomes harder and harder and harder to do the later on you get. I think it's also really important to keep in mind too that if you're to the point where you feel like capacity is an issue, you might be too late to make a good decision. And if there's any kind of family fighting, if there's any kind of, I won't even say that, if there's any tinder to start a fight, doing those kinds of documents then, or taking action when there's already a question of capacity, is just the start of a potential fight. Right? So doing it long in advance. And the last thing I will say, and I admit I tried to find it again, I could not find it before this conference, is I saw a statistic one time that talked about, especially from the time you're 18 until really you're in your 60s, death is far less likely than incapacity, substantially so. It is the thing that can happen because of an illness, it can happen temporarily, or it can happen due to a severe traumatic injury as well that doesn't result in death. So it's always the one that has, frankly, the greater risk and greater likelihood of happening even earlier than death. So it's never too early, I guess is the point.
Everything he said. And because you could step off a curb and get hit by a bus. I mean, we can't know what will happen to us tomorrow. And it is important to plan and protect your family. And to his point, if you have multiple children or people who might vie for a role in caring for you, it makes it doubly important. And I consider part of what we do to look at the family dynamics and try to preserve family harmony. So I have conversations with my clients about who the people around them are and
That's my next question.
who would serve.
Who should serve as a power of attorney? Let's talk about that, and who are the ideal candidates as people think about their own families and their own lives.
The ideal candidates are, number one, people you trust to make decisions for you. So it may not be the natural first person based on who's closest to you legally, but generally, if my clients are married, they choose their spouse first and foremost. And then generally, if they have adult children, they choose their adult children. We have two types of powers of attorney. We have our durable power of attorney, which is, again, financial, and we have a medical power of attorney. They are two separate documents. There is no one general power of attorney in the state of Texas. So if anyone's offered you that, please don't sign it and think that you're covered. So the conversation then becomes, who's best with finances? Who is able to work with a CPA and your financial advisor?
On the durable
on
side,
the
because
durable.
you could have separate
Correct.
agents for each of these
We've
two
got
different.
two documents, and I'm going to say who's the best money manager, who's the detail-oriented person, who's going to understand when New Capital Management sends a statement, who's going to be able to read it and understand it. That's your agent under your durable power of attorney. Who is better at making medical decisions? Who would make your medical decisions in a way that's consistent with what you would do if you're unable to do that? That's the person you name for your medical power of attorney. Kevin, got anything to add?
Just a few. So I will say that with this, I certainly agree with you want to look for the person who's good at this, and you kind of have to be harsh. This is a conversation you have to have quite a lot with clients. They might have 3 kids, and what they want to do is name the 3 kids, and a lot of times they default to the oldest to the youngest. I'm saying this as a middle child, that the oldest is not necessarily the best. All right? Yes, we are. Touché, sir. So I think you have to be, it's a hard thing, but you really do have to be pretty objective and think about who's going to make good decisions. There's oftentimes, and I have, again, this conversation all the time, very recently I was meeting with a client where we were going through who their agents already were to revisit to see what they should be. And they visibly winced, like they were in pain when I said the person who they had named. That was not a good sign, or really a great sign that that person is not the answer, right? So somebody who is good with money, if they have their own financial problems, they have a huge incentive to steal, or there's the specter of them stealing, and that's not going to sit well with other family members. So anyone in that position is probably out. I will say one thing, because this question comes up a lot, is people will look at things like, should you consider their age, geographic proximity? A lot of times people will say, oh, they're the one here and everyone else is abroad. That can be fine. I will say that in terms of who's physically closest doesn't matter as much anymore, because we have a lot of e-banking. You can do a lot of things electronically. You don't have to be physically here to go to the branch 9 times out of 10. And then age is not necessarily a reason not to pick the person. You know, like an older client might name a sibling who is excellent at this. That's perfectly fine. Name that person. If they're the best choice, name that person. Age means they may not be there when you need them to do this. That just means you want to make sure you have decent backups so that if this option goes away, if the best option isn't available anymore, you're set up for the next option.
That's an excellent point. I always want to name at least one alternate for every role. The deeper your bench, the better. So the conversations during these meetings can sometimes be exhausting, because I'm continually saying, well, and if that person's not around, then who? And if that person's not around, then who? But we want to make sure we have a sufficient number of people to protect you if you need protecting.
And Tonya and Kevin, what conversation do you have with your agents? If you have this deep bench, as you're saying, primary and then second and then third, what should you do? You should give them the documents. Do you have a meeting? You have a phone call? What's sort of the best practice so that this isn't just something that if it was ever needed, that they're just gets dropped on them and they don't even know?
It should not be a surprise to them that they hold your power of attorney. So if you don't feel comfortable giving them a copy of the document and talking to them about it, that is a big red flag that you should not name them as your agent. So yes, they should have a copy of the document. They're going to need it if, again, you get hit by a bus when you step off a curb. But a conversation is critical. I, for most of my clients, advocate transparency with the people in their lives who may have to step in and take care of things for them. As a part of our process, we collect information. We have a spreadsheet with all their assets on it. We have their main advisors' names and phone numbers. There are lots of information gathering tools that you can use. I provide some of those for my clients, and I want them to share that with the people who might need to support them. The more information, the better. If you're not comfortable sharing actual numbers with the people in your lives, for example, your account balances, they need to at least know where to go to find it. It's in a binder, in the safe. The key to the safe is in the top left of my desk drawer. So if there's an emergency, you may go look. That's one layer or one end of the spectrum. The other end of the spectrum is such as I have for my own mother. I have online access to all of her accounts. I can check them at any time. She's given me complete carte blanche to do anything that she could do to get access and information. And she's put me on the trusted contact for her broker dealer, so I could call her investment advisor at any time. Kevin, you want to add to that?
I do want to add a little bit. So I certainly agree with the majority of it. I admit, I think this question is a hard one because I think it's very client driven. I've had situations where I tell people, I don't think you want to tell all of the agents that you've named them, especially in more tumultuous relationships, because you don't necessarily want number 4 to know they're number 4. And if you give everyone copies and you change your mind 6 months later, then you kind of want to go back to those same people and say, oh, by the way, you're out. So if that's going to be a really difficult conversation for some of those, you may not approach it that way. I will add, though, to Tonya's point, I think this is a great thing, is that sometimes people think of estate planning documents as documents you fill out, that you put into a binder, and someday you'll need them again. Power of attorneys are more living and breathing than that. It is something you want to do with your agent. I've had situations where a person does have that instantaneous hit by the bus incapacity, and their child does not know that they were the agent, and they don't know anything about the assets of their parent. They don't know where to go. They don't know where to get the information. They don't know what bills they are to pay. And it's not the easiest thing in the world, but especially as you age, it's good to bring those I'll say the agents or those trusted people into what you're doing so that they know what's important to you. They know what your preferences are. For example, this is a little bit further, but let's assume under a power of attorney, you already make charitable gifts every year. You might want your agent, you might authorize them to do that. The fact that they can do it doesn't mean that they should do it. But if you want them to do it, that's a conversation that you need to have with them. So I suppose it's hitting several points of you have to be kind of specific to what you need, but you definitely have to bring those people into information, knowledge that they can actually do a good job for you, not just dust this off when the time comes.
And I'll just make a plug again for many of you know the work we've been doing in NCM 360, and especially the features we added last year were collaboration features, so that information, data, documents, and so on that are stored there, you can designate that information to be shared with particular trusted people, and they can gain access that way. And increasingly these methods are digitizing. Yes. Systems and share vaults and share boxes and so on. So I would guess things are getting a little better in that respect. Yes. It's easier to share something that is on a server. Yep. Rather than stuck in a vault somewhere that nobody, including you, ever take a look at. So, is that maybe you'll talk about that? Do you think that digital vaulting of these documents is an improvement, or we understand there's security issues, but leaving aside the security issues, do the two of you feel that we're heading in the right direction to be able to collaborate and share the documents in a better way?
So that's a really good question. I would say yes, it's an improvement. I would say that it's interesting because the law hasn't necessarily caught up with the technology, which is a very common legal problem. And so, like, for example, and this is again outside of POAs, but An original will is what you want to probate. That means wet ink signature. So a digital copy is not necessarily going to be ideal for that. But for powers of attorney, digital copies work in most contexts. Not all, but most contexts. So I would say it's better. I think it's certainly better in the sense that then you can share so much easier. You don't have to wait to give paper copy to your child when you see them at Christmas or something like that. You can just send it to the people who need it, and it's certainly much easier for sharing with advisors or other appropriate financial people. So in that sense, it's great.
Tonya, how do you see it, this question of digital?
I think it's a vast improvement overall. Security issues notwithstanding, we always have to do our best to protect our sensitive and private information. That notwithstanding, having ready access digitally and in an easily transferable, shareable way, I really think has changed the game. I would say that unfortunately, sometimes people come to my office with 20-year-old will packages for updating, and they come in and they slap down this whole packet of information on my conference room table, and it includes the 3 copies that they were supposed to distribute to their children
20 years ago.
20 years ago. Now, if I email you a PDF, it's very easy for you to forward that email to your children. Or if you give me permission, I'll email everybody immediately. And it's as simple as that. And everybody's got what they need to take care of you if you need protecting.
We have some slides. I'm in control of those. Is that right?
We printed.
Oh, we printed them.
We
Okay.
so you guys have a handout, which hopefully should echo a lot of what we've already covered. And then we've got a couple of them in slides too. So this is my, I won't blame Kevin if there's an error in it. I'll take credit where there might be a mistake. But this is my best comprehensive list of the documents that one needs for protection of oneself during life, potentially during incapacity. This does not include a will, because your last will transfers your assets after your death. But the medical power of attorney, we need a living will, also known as a directive to physicians that expresses your wishes if you're in a terminal or an irreversible state as certified by your physician. This is where you get to express whether you want life support or you want comfort measures only. We need a HIPAA authorization, and that is something that I think is critical for those just turned 18-year-olds and anyone who lives remotely. If your elderly mother who's in another state is in the hospital and you need to call the physician to get an update, your mother must have signed a HIPAA authorization so that the hospital or doctor can release your private medical information
Or they won't talk to you.
Or they just won't talk to you. And there are all kinds of stories about college student health centers who won't give information to parents about their child who's in the hospital because they can't. So HIPAA authorization, in my mind, is critical. Here is your financial power of attorney, also called statutory durable power of attorney. And I have my clients sign a document that's called Declaration of Guardian in the event of later incapacity. It does not shortcut the normal guardianship process, which is onerous, but it does state who you would want to be your guardian if a judge ordered a guardianship for you. And under the law, the judge has to follow your wishes unless those people are disqualified because, for example, they're a felon.
So why would a judge order guardianship if you had power of attorney? Would it be that the power doesn't hold up, or it's suspect, or?
Occasionally, and digital vaulting actually helps with this. Sometimes we would lose a page and then the whole document would be suspect. So now digital copies are helping us preserve enough copies that is less of an issue. If there's a dispute by a family member over whether you had capacity when you signed your power of attorney and they run down to the bank and they say, Mama didn't know what she was doing when she gave my brother power of attorney, the bank is going to step back and not honor your power of attorney. But here's the number one reason that even if we have valid powers of attorney that are working at every institution, we might still need a guardianship. A power of attorney enables someone else to act for you, but it does not restrict you from acting for yourself. And some of us will develop a dementia that might impair our judgment, and we might begin to act against our own best interest. So an example is a financial scam where an elderly person is talked into giving away their money. And there's no stopping them. It's their money, unless and until a guardianship is put into place, which restricts someone's right to act for themselves.
And in that case, when you were of sound mind, you had established this declaration of guardianship.
Correct.
And it makes it a lot easier for that appointment to take place to make sure that you don't continue to act against your own best interests.
That's exactly right. Kevin, you have anything to add?
You said it all.
Thanks.
Which brings me to ask, how often should you be reviewing this? If you, let's say you appointed and completed powers of attorney 2 decades ago, is it, you know, things could have changed. You might have named a sibling and the sibling might be deceased, or you're estranged from the sibling. Anything could happen, and so presumably you need to do some sort of review of what you've done.
So I think, particularly with powers of attorney, this is maybe more of a general estate planning. I think people should look at them annually. If for no
Wow.
other reason, because if I say annually, you'll do it every 3 years or 5 years, and you'll look at it often enough. But powers of attorney are always something that is really ripe for updating for 1,000 reasons. Amongst them, think of it like this. Who is in your life? You know, how this fits is sort of like a suit of clothes. You're in a different situation in the future, and you need something different. So the power of attorney really does need to get updated to match new agents, new powers, whatever the case might be. This is also an area of law where powers of attorney have changed many, many times. The concept of a will is more than 2,000 years old. You know, like it's really not, there's not major changes with wills, but powers of attorney, because people can be so directly affected by them, are often changed, updated, tweaked, the powers are adjusted, so having them updated to match those new options is really good. The third point, and I always like to tell this to clients because I think it's a very easy thing to lose track of. If you hire an attorney to do something, you kind of assume it's legally correct, right? That's probably a fair assumption on your part. But part of what we as practitioners strive to do is not just to make it legally correct, but also to work well. And with a power of attorney, you're not presenting it to another attorney who says, oh yeah, Kevin did everything he was supposed to here. You're presenting it to a bank teller who doesn't know. Or you're bringing it to the closing table, or you're bringing it to some other third party with no legal background or knowledge. And so as the law changes and creates new forms and new structures for how to do this, it is really helpful to have the most up-to-date version all the time, because that's what the bank teller is going to know, right? That's how, that will make it work. Even if the one I did 10 years ago was legally valid and still is, that's the one that will work, all right? So updating is very important in POAs.
Which leads back again to the idea of digital vaulting, making that process easier. If you have to go dig it out all the time, it's harder. If you can pull it up on your phone and see, then it makes it easier. Tonya, you were going to add something to Kevin's remarks.
I agree with him. Having a current, fresh power of attorney that is familiar to the people that you're going to present it to is critical. And the legislature updates the form that is recommended every 2 to 3 years. I mean, they're in session every 2, and they hit it at least every other session. So my practice is to send out a reminder to my clients every 5 years to give us a call and visit with me and review their documents. I like Kevin's statement, you should review your powers of attorney at least once a year. But you're going to at least touch base with your attorney every 5 years and make sure there aren't changes. Even if you don't have any changes, make sure there aren't changes on the law side that would warrant an update.
How do you rescind a power of attorney?
With a legal document that revokes it. So I, as your lawyer, would draft a 1-page revocation. It is critical that everyone you've ever given that power of attorney to receives actual notice of the revocation. A bank is entitled to rely on a power of attorney, and until they know it's been revoked, they can continue to honor it.
So you can't just say, well, this
You
is no
can't-
good anymore.
You can't say, I'm mad at you, daughter, you don't have my power of attorney anymore. and ripping it up doesn't even effectively revoke it if you've given it to some third party who is still entitled to rely on it.
If I may, really quickly. So one interesting thing, though, and you actually in the statutory form have this, is a power of attorney is only effective during your lifetime. So one way not of rescinding it, but to have it become valueless, is to not have agents who will serve. If no one's alive, capable, or willing to serve, you essentially have no power of attorney. It terminates. So it's a same issue, different approach, different problem. It shows how it's really important to have the correct agent so it doesn't essentially get rescinded for lack of appropriate people.
We've got about 5 minutes left. Any questions? John, please.
Just thinking about a third party who might have power of attorney, and a bank is required to honor.
So the question is, if you've, and I'll summarize it and you tell me if I got it right. If you've revoked your power of attorney, but the agent under the revoked power of attorney presents it to a third party, how is that third party going to know it's been revoked? So it's a challenge. There's no central registry or depository. That's why when you revoke a power of attorney, it's incumbent upon you to notify every bank that you know has previously seen it and to try to retrieve any copies that you might have given to that agent. Ultimately, agents under a power of attorney, I'm so glad we got to this piece, they have a fiduciary duty to you. It's the highest duty under the law. They may be sued on your behalf, and they may have to not only pay for any of the damage they directly caused, but pay punitive damages and attorney's fees for violating that fiduciary level of duty to you. So if somebody who knows they shouldn't, because the power of attorney has been revoked, shows up at a bank and does something in your name, they are subjecting themselves to liability. But the bank is entitled to rely on what's presented to them. That's the banks protecting themselves.
There was a question that came in online, and if you could repeat it again as well. When I die, does the power of attorney evaporate?
Question, when I die, does the power of attorney evaporate? Kevin, you want to take it?
Yes, it does. And so actually, much like I was alluding to before, there are 3 reasons in Texas, right written into the statutory formulas, because we didn't have a reason to say this, but Texas, in an effort to avoid things like fraud with powers of attorney, has come to a really, rigid is maybe too strong of a word, but a very specific layout of how you're supposed to create a durable financial power of attorney. And of the list of 3 things at the top about how it can go away would include a guardianship, can evaporate it. The person lacks agents, as I said, and then your own death. So at death, power of attorney is over.
That is a very common misconception, I will say. Many, many people try to continue to act for their deceased loved one because they have the power of attorney. And some institutions might even allow them to for some period of time, but they shouldn't. It should terminate immediately upon death.
And your executor at that point
Correct.
takes over, as it were,
Once they're appointed by the court.
appointed by the court.
Another online question. It says, is it enough to refresh the power of attorney from online documents without sitting down with a lawyer if the documents were created in 2011, so 10 plus years ago?
Okay, so to repeat the question, is it enough to refresh your powers of attorney based on online documents?
It wasn't supposed to be online. It was a typo. It said, were they able to refresh all of their documents without an attorney, basically, if they're over 10 years old?
No. And the basis of the question is, should you do this DIY? The answer is no. The forms that are online are very likely to not be state specific. This is a state specific area of the law. And so there are companies, LegalZoom is the main one, that have created forms, and or if you Google power of attorney, you'll find something. But is it a Texas specific form that is the current form that is accurate it's impossible for you to know that without counsel's opinion. And so in my mind, it's pennies wise, pound foolish. It can create more problems than sitting down with an attorney, and we're not that scary, I hope. And we're also probably less expensive than you think we are. And it's well worth it to have counsel for this because, again, these are critical documents. We have one out in the audience.
Kevin wanted.
If I may, let me just give a little bit more to that because there was the question before about the guardianship, and I think Tonya raised it about when a guardianship is needed, even if you have a POA. I have typically seen that not when it's an offensive guardianship to stop a person from doing something. I've seen it in the DIY bad POA that technically there is one, but it's useless or it's bad. I mean, actively bad. So, I mean, in theory, it can be done legally. Done well is a different question. The other reason why I was going to say I don't think this is something that people want to do on themselves for power of attorney is, and we probably don't have time to get through this really, but powers of attorney, ideally, you're crafting the powers of what this person is. If someone else is walking in my shoes, I want to have a say about what they can and cannot do, right? They're representing me going forward. An attorney really has to be involved because powers of attorney impact everything from simple incapacity decision-making, go to the bank for me, pay my bill, to what are my tax options should things change in the future? What about long-term care? What if I need to make gifts? What if I want to fill in the blank, right? Any of that, a lot of that you need to speak to an attorney about what the impact that's going to be so the power of attorney actually works as intended.
I understand the importance of using an attorney for medical power of attorney. What about for HIPAA? What about doing online forms for HIPAA authorization for college-age kids? Is that misguided?
So I'll repeat the question for, she acknowledged the importance of an attorney for doing powers of attorney, but is curious if we could use an online form for a HIPAA authorization. So as you can see from my table, there is specific language that is required by federal law for a HIPAA authorization. I can't promise that what you find online will contain the right language. Here is, though, what I say to my clients, all of them. When you go to a hospital or a healthcare provider, they may ask you to sign their HIPAA authorization. And I don't have a problem with you signing that. It's not going to revoke the global one that I do for you. And don't give the person on the other side of the counter grief. They've just been instructed to give you a set of forms and you're supposed to sign them. So you can have multiple HIPAA authorizations out there. And if there's a institution-specific one that your child's college puts forth, absolutely, sign it. What I don't want you to do, number one, I want you to have attorney prepared everything on this list. And number two, I don't want you to list different people on any hospital or doctor-specific forms than you've listed in the global documents that you've prepared with me. Does that make sense? Because then you create inconsistencies that people aren't sure which document they should be able to rely on.
There was a question here, Kelly?
So I assume your recommendation that for a power of attorney for an 18-year-old who may be going off to school would be the same for a young adult. They've made it through college in their 20s and they're living independently, but still would recommend, I guess, for more incapacitation or medical emergency or something.
Right. The question was, does the same recommendation for 18-year-olds apply for young adults in their 20s who are a little further along in their process? And my answer is that it is universally the same for everyone, that we all need all of these incapacity planning documents. In addition, if someone owns any property, they need a will that disposes of that property at their death. So at the point in time where we start to acquire assets, then we need to add a will to the package. And the only reason I don't do a will for 18-year-olds is because most of them don't own anything. They may have a bank account, and we do a TOD designation on their bank account to their parents so that if something tragic happened, the parents would collect the bank account.
Other
Kevin?
questions? Tonya and Kevin, thank you so very much. round of applause for these two fine professionals. And if you need any assistance with your power of attorney or other documents, they will be happy to help you.
Yes, we've both left business cards here on the table.
Business
on the
cards are
side.
here on the table. Catherine, can we take just a couple minutes? Is that all right? We'll take just a few minutes and let people run to the restroom, and we'll get started again at 25 after, promptly at 25 for our last presentation of the day, and we should be able to move more quickly through it. Okay, thank you, everybody.